Welcome everyone to what is the first event of this year for Queen Mary Intellectual Property Research Institute, QMIPRI. My name is Uma Sudarsanan, and I am the current director of the Institute. And I'm really pleased to have this starting the whole year. It's a topic dear to my heart, and I think to not just all the academics in UK and around the world, and to the publishing industry, but to a lot of us concerned about rewarding authors and creators, as well as seeing access to publicly funded research, especially after the last 2 years. I'm not going to mention what happened though. And I will be also talking again about the Institute's work, but just to say, before you log off, and in case I forget, we have 2 other events planned for February and March, and they will continue the discussion on copyright law. For February, we will have a seminar that will focus on theater and drama works, with commentators from Queen Mary School of Drama, and also Yusol Gendre from Montreal, who's just done a report on WIPO actually, on performance and copyright. And after that, we will also have a book launch of my colleague Jonathan Griffith's book on IP and New Constitutionalism, with commentators from around the world, including Graham Dinwiddie from Chicago Kent School of Law, who used to be with us. But without further ado, I'm going to introduce the main presenter today with her research. I'm really pleased to have met her. I'm so pleased she chose to be with us for 3 months, and we never got around to lunch, but we will. Professor Asunción Esteve from the University of Barcelona. The commentator for this afternoon is Matthew Day from Cambridge University Press, and he is head of open policy and partnerships. So I'm going to give the floor over to Asunción, and then Matthew can take over.
Thank you very much, Uma, for hosting me here at the Center for Commercial Law Studies in London, and for organizing this webinar where I can discuss with all of you the conclusions on my research on open access to scientific publishing. So I think that a very good description, a short description of open access is in this phrase by Peter Saber, who is an American philosopher and one of the leading voices in open access. And he describes open access literature as digital, online, free of charge, and free of most copyright restrictions. I think that here, free of charge and free of copyright restrictions lie the issue questions about open access. Free of charge is not the same as free of copyright restrictions. For example, this journal, which is a Spanish journal on civil law, which is a very good journal, one of the best, is free of access. Anyone can download a copy of the articles for free, but the articles are totally copyright protected. That means that no further copies can be made, no free distribution is possible, no dissemination for any reasons is possible according to copyright law. So for this reason, the open access, many supporters of the open access movement see copyright as a barrier to open access. And they consider that scientific publishing should be free of charge and totally unrestricted. So free of charge, meaning no paywall articles. Anyone could be able, any reader could be able to get an article for free, and unrestricted. So the copyright should be removed. For this reason, for example, it is stated that a removal of copyright protection to scientific works forces a universal open access regime. But that that needs to answer one question. Is copyright protections to scientific works needed? Is it justified? The issue behind that is that scientific knowledge is a public interest. It's good for the whole society. For this reason, for example, the Charter of Fundamental Rights of the European Union in Article 13 declares that arts and scientific research shall be free of constraint. Of course, this fundamental right is not absolute. If it were absolute, copyright wouldn't exist. So it coexists with copyright. Also in the Spanish Constitution, for example, and other constitutions also do that, public authorities have the responsibility to foster and protect the access to culture and to promote science and scientific research. But that also doesn't mean that copyright should be removed from scientific articles. The Berne Convention, which is, as you know, the international treaty on copyright, grants copyright to any author who creates an original work. It doesn't matter if it is a musical work, an artistic work, or a scientific work. The author has the same right. However, the copyright law also modulates the scope of copyright, taking into account interests as, for example, scientific knowledge. Thus, this public interest on scientific knowledge justifies that copyright law should make open access mandatory? I don't think so. And this is what I am going to explain in my presentation. Moreover, even if copyright didn't exist at all, even if authors of scientific works were removed from their copyright, publishers may charge for the scientific publishing because they made an investment in publishing. So they are offering a product or a service, and if it is not copyright protected, this product or this service implied a previous investment. So they have a right to ask for a price. So the solution is to find a balance, a proper balance between the interest of the different stakeholders in scientific publishing. These are the four stakeholders behind open access to scientific publishing. We have the funders. Many of them are public because the public authorities have to foster scientific knowledge. Their interest is to maximize dissemination of the research. And for this reason, they impose an open access mandates to the researchers that benefit from their grants. This is a good wish, of course. This is very positive for the society, and it has a justification because they also invest. On the other hand, we have authors who create scientific works, and their top interest is to publish in high impact journals. But they also want credit for their work. For this reason, the moral right of attribution, the copyright moral right of attribution is so important for them. And they also want to be cited. So they are also interested in dissemination. So they don't mind to give up some of their copyright if publishers agree. Then we have also universities, librarians from universities and research institutions. Their interest is to promote the scholarly communication, the dissemination of scientific articles among the university staff, the researchers, for free, for educational reasons, for scientific reasons, and they also complain, with reason, I believe, that the prices that they pay for subscriptions to scientific journals are too high. I will also go on this issue later. And finally, we have the commercial publishers. Commercial publishers are mainly interested in profit margins. And they are also interested now in open access strategies because they know that's the future of scientific publishing. So open access implies free access, otherwise we are not talking about open access, but not a restriction and absolute disappearing of copyright, but to minimize the copyright. So authors can diminish the copyright restrictions by authorizing uses of their works to the public by means of these public licenses. And these, the most famous ones that most anyone knows are the Creative Commons license. Here we have the less restrictive Creative Commons license. Here, the author authorizes any use of his work, but only demands claims to be cited. The Finch report, which is a report on open access, which was submitted in the UK in 2012 and fostered a lot the open access in the UK, recommended the Creative Commons license attribution. However, this Creative Commons license poses a problem because it does not restrict commercial uses of the works. And for example, the University College London here in London has a press, University College London Press, that publishes everything in open access, and they use the Creative Commons attribution license. They didn't restrict commercial uses. And what happened? It happened that someone was selling one of their books on Amazon, and they couldn't sue him because there was no copyright infringement. For this reason, it's much better to use the second Creative Commons license here indicated. So what are the present-day channels for publishing and disseminating research? We have mainly three channels. First, the traditional one, subscription-based journals. They provide paywall articles, so it is necessary to pay for the subscription, and then the articles are totally copyright protected. This is the old model that still exists now. Then we have open access journals. They are new. These open access journals offer free access to the articles. There are no subscriptions, and the articles are published under a Creative Commons license. This is the so-called gold open access. And then we have the third alternative, which is the repositories. The repositories normally belong to universities, and in the repository, the author can deposit his articles. So if articles haven't, or a thesis, for example, if they haven't been published, he will deposit them under a Creative Commons license. But if the articles are published, the author must respect the embargo period that the publisher has imposed, and he only can deposit the manuscript version of the published article, not the final published version of his article. This is obviously a restriction to total open access for publishing articles of scientific articles. However, as we know, many commercial journals are now also publishing some open access articles. For example, we have here this journal, which is a commercial journal, and it has this article in open access, but not all of them, only some of them. So open access journals also need income because publishing open access articles imply also costs. So open access journals normally charge a fee to the authors, which is the so-called article processing charge, APC. The average of APCs for open access journals is around £1,000. They either charge a fee to authors or they just get money income from advertising or sponsoring organizations, and then they just recoup costs. So they don't get profit margins. By contrast, commercial journals, when they publish some open access articles, the APC that the author has to pay is the average is £2,500. So it's much more expensive because they are interested in profit margin. But the main problem is that has a double dipping effect because these commercial journals are asking for submissions, they charge subscriptions, and at the same time, they are charging these fees. So we have this double dipping effect that makes that commercial journals are getting money, double incomes, not only from the subscriptions, but only from the ABCs. Any open access article, any article which is published in a journal in open access must be published under a Creative Commons license, and therefore there are new open access publishing agreements between author and publisher. Here, for example, we have the open access publishing agreement between Elsevier and an author. There is always, if it is a commercial journal or if it is an open access journal, in these cases, there is always a grant of an exclusive license. So there is always an exclusive right, which is granted by the author to the publisher of the open access journal, or to the publisher of the commercial journal that publishes in open access. And then that's new. These open access publishing agreements, they include always this user rights clause, where it is stated that the publisher applies the Creative Commons license. Normally, it is the author who chooses the Creative Commons license, but here in this Elsevier agreement, we see that Elsevier imposed this Creative Commons license that has 3 restrictions: attribution, naming the author, non-commercial journal, no commercial uses, and no derivative uses. Well, so that's the situation, how open access works. However, what are the problems? What are the main problems at present in open access? The problems are that commercial journals have some advantages. They have advantages over open access journals. What are these advantages? That they have higher impact factors than open access journals. So it is stated, and this is really that has been contrasted by information technology experts, that the best articles are published in hybrid journals, so in commercial journals that offer also open access articles. But this hybrid model, as I said, has this double dipping effect. So the journals charge for subscription and for the ABCs. So this is a problem. Other problem, commercial journals also have advantages over repositories, which are, in the repositories, authors can only deposit the manuscript version of the published article, whereas in the commercial journals, we find the version of the record, the final version. I'm going to explain what is the manuscript version. So when an author submits an article, if the article is accepted, then it goes through a peer review process. The author incorporates the comments, the changes, the article is improved, and then the publisher, if he agrees with the final changes of the author that the author makes, and after the peer review, he accepts the manuscript. This is the accepted manuscript version. This is what an author may deposit in a repository after the embargo period. But the final published version of the article is the one that adds the copy editing, the typesetting, the logos of the publisher, the final pages of the article. And I think that most of researchers prefer the version of the record rather than the manuscript version. Also, in the repositories, we don't find articles just after publication. We must wait until we must wait for the embargo period. That can be 6 months, 12 months, and then the article can be outdated. In the commercial journals, we find the most recent articles. And the final reason why the researchers we are not so fond of repositories is that they are a bit chaotic. So there is a vast of scientific articles. Whereas in the journals, we find that first, selection of best articles. Many journals, especially high impact journals, they receive a lot of articles, and they select maybe the 10%, the 20%, the 30%, the 50%, but there is a selection of the best ones. The ones that are selected are also improved. So we can get the best articles. Moreover, journals are structured in areas. So if we are interested in mathematics, we know which journals have articles of mathematics or of law or of history. So we can say that journals act as a filter for the best articles and organize the research area. And this is, I think, a very important contribution of journals. Well, what are the solutions to expand the open access? How can we find a real open access to scientific publishing? There has been some initiatives in some countries to change the copyright law. This happened in Germany and in Holland, because they amended the copyright to introduce an open access right. Also, France introduced this open access right in the Code de la Recherche in 2016. What is the problem? This open access right was recognized to scholars, but it's inalienable, so they can transfer that to the publisher. But they can make the accepted manuscript available to the public in a repository after 6 or 12 months. So it's not immediately after publication. So the copyright law, this copyright law, tried to find a solution to open access to scientific publishing, but they had also to take into account the interests of the publishers. And the interest of the publishers here is to have an embargo period, to be able to get back all the investments that they have done for the publishing. So I don't think this is really a solution that fosters open access. Another option is funders. Funders try to make open access possible by imposing open access mandates to the research. The United Kingdom Research and Innovation, which is the most important public funder in the UK, has an open access policy, and for April, next April, it is stated that a publisher embargo period between publication of the version of the record and open access of the deposited version is not permitted. I wonder, I think this is very, we all wish that could happen, but this open access policy is not binding publishers. This open access policy is binding on researchers. The open access mandates are between the funder and the researcher. If the researcher doesn't respect this open access mandate, and if he publishes his article with an embargo period because the publisher imposed him or her an embargo period, the UCRI could sue the researcher. But this mandate cannot be, doesn't have effect on the publisher. Funders are also trying to organize themselves. For example, the Coalition S is an organization of public and private funders, and they also try to promote that all the articles that are that get funding from public or private institutions, charities, for example, they must be made immediately available through open access repositories without embargoes. But I also think the same. So this is a good desire. This is a wish, but it cannot force publishers to do that. University policies. Here in the UK, I've read this university policy of the Edinburgh University on research publications, and they state in order for the university to and its researchers to comply with funder requirements. And they have adopted this mandate, upon acceptance of publication by a journal, each staff member agrees to grant the University of Edinburgh a non-exclusive license to make the manuscripts open access available. So I think this is, I mean, I don't quite think that this is legally possible. I think that if the journal is not informed, if the publisher is not informed that this author, that this researcher has made their research under some public funding before, he cannot be forced. The journal doesn't have to accept that the author is going to give a grant to the university, to grant a license, a non-exclusive license to the University of Edinburgh if the journal doesn't have prior notice about that. So I think that instead of this, the University of Edinburgh should say something like, the author should give prior notice of the open access mandate to the publisher when submitting the article, but not upon acceptance. He cannot say upon acceptance of the article by the journal after the peer review process and improvement of the article. Now, I'm sorry, I'm going to give a license to my university in order to permit the scholarly communication. So I think the publisher could reject to publish his or her article. So for me, the best solution for open access to scientific publishing are the negotiations between institutions and between the publisher of scientific journals. What is the problem here? The problem is that very few publishers have almost of the scientific journals in the world. So Elsevier, Springer, Wiley, Blackwell, Taylor and Francis, Oxford University Press, Cambridge University Press, they have almost all, 80% of the scientific journals. So the problem in the scientific publishing market nowadays is that there is a high degree of concentration of ownership. For example, Elsevier or Taylor and Francis, they have around 3,000 journals of scientific articles. Oxford University Press, Cambridge University Press, they have around 400 journals. So there is an asymmetry when research institutions and universities try to negotiate subscription agreements with them, because they impose all their journals to the institution, and they are not able to know, universities are not able to know exactly the costs of publishing, and there is no transparency on these costs. So how much a journal pays to the editor, if they pay to the editors, I don't know. How much do they pay to peer reviews? They don't pay to peer reviews. They don't pay to authors. So the costs are what? Typesetting, proofing, amendments, language editions, indexing, journal management and developing, and how much do they really invest in this? However, the path to open access, I think, is now that institutions, libraries, universities and research institutions are entering into new contracts that replace, that change the traditional subscription agreement, and they are the way to open access. These are the read and publish agreements. These read and publish agreements are quite new. They started like 4 or 3 years ago, and the institution pays a fee, which is more or less the same fee that they used to pay for subscription. But this fee not only allows the researchers to read, they also allow some researchers to publish in open access in the journals of the publisher without paying additional APC fees. So this is the way of eliminating the double dipping effect. So the fee covers a number of APCs for article. I'm going to show you an example, a real example of the read and publish agreement, which has the Spanish National Research Council has entered with Oxford University Press. So this Spanish National Research Council, has around 100 institutes. All of them are for science, medicine, chemistry, biology. And Oxford University Press has 400 journals. So this institution is paying for all the journals, even, for example, the Journal of Intellectual Property Law, which is of no interest for these institutes, because these institutes are only and purely on science. So the fees, how they work. This is a read and publish agreement for 5 years. The fee is more or less the fee that they used to pay this institution for the subscription. But this fee, which is quite high, so it's almost 200, so it increases a little bit every year, but it is almost £200,000 per year. Now it includes articles to be published in hybrid journals of open access, in hybrid journals of Oxford University Press, and in open access journals of Oxford University Press. So the first year, this fee covers 45 articles in open access. The second year, this fee covers 58. And the number is increasing. And in the last year, they will be able, the researchers from these institutes, they will be able to publish a total amount of 100 articles in open access in journals of Oxford University Press. But we see that there is a price. There is a price for publishing in open access. Of course, the price is different. For example, in the case of the University of Barcelona, the University of Barcelona has also entered into a read and publish agreement with Cambridge University Press for 3 years. The prices are much lower because there are not so many researchers, and this price splits every year between reading or publishing in open access. So the rate for publishing in open access of this price will be increasing. What is the effect of this read and publish agreement? So if more institutions around the world, universities, research centers, enter this kind of read and publish agreement with publisher, the share of open access of articles all around the world in all the journals, in Oxford University Press journals, in Cambridge University journals, in Elsevier journals, it will increase. So institutions, universities, which are small, which don't have so many researchers, they will stop paying for subscriptions or for read and publish agreements because everything will be in open access. So that will produce an effect on the incomes of the journals, and also some institutions, big, large universities will have to pay a lot for making possible open access to scientific publishing. For this reason, there are also increasing the alternatives to scientific publishing without journals. We have, for example, Octopus, which is an initiative where anyone can upload an article, peer review happens openly, other researchers evaluate and rank your article or make comments on it. But again, we don't have journals. And I think that journals' contribution is important. They really improve articles and they organize the research area. So finally, I'm going to finish here. My conclusions are: scientific publishing is expanding to open access with no turning back. I think it's the future, that this is going to happen. But someone has to pay for open access to scientific publishing, and it's not a copyright. So copyright deals, okay, it suits, okay, with all open access. Authors, they just minimize their rights. So open access is not a copyright problem. The problem that, the real problem to make open access to publishing scientific now is a competition law problem, because the problem is how much the publishing of open access of scientific publishing costs and who is going to pay for that. But mainly the main problem is the correlation, the fair correlation between the fees for publishing in open access and what are the real costs. And with that, I finish. Thank you very much.
Thank you, Asunción. That was really terribly interesting, especially the read and publish agreements. And I hope that you will be publishing the research of your work soon, so that we can read it, very slowly. But that was actually fascinating. To pass this on to Matthew, I think I got a two-line conclusion from Asunción. Basically, who pays and is copyright futile. So, Matthew, over to you.
Okay, thank you very much. It's great to be here. It's really fascinating to hear kind of open access discussed with the perspectives you've given it. So I think it's a really complicated set of things going on here, and actually kind of listening to you and looking at some of the comments in the chat are causing me to rethink what I was going to say. So I'm going to deviate from the script, which will be fine, I think, as long as you're willing to forgive a few hums and haws as I'm kind of gathering my thoughts a little. So to add some context, so I work at Cambridge University Press, which is a part of the University of Cambridge. It's part of academia. It's part of the research ecosystem. And yet it is a financially self-supporting university press. We're not subsidized. We have to generate surplus so that we can change, develop. So that puts us part of the publishing industry as well. And we sit on the meetings with the big commercial publishers, on the industry bodies. So we see issues from both sides, and what the press has done over the last, particularly the last 5 years, is it has fully got on board with open access. Right? Before then, it was agreed. I think it would be a nice idea. Wouldn't it be good? Surely, if we could, why wouldn't we? Those kind of discussions. But now it's committed to doing it. It is going there. To get as much of our research, ideally all of it, open access, fully open access under Creative Commons licenses, by 2025 or this kind of timescale. And the two big areas of difficulty, one is economics, as we've heard today, and the other is the licensing issues. And both of these are very complicated and entwined. And sometimes one gets used to address problems in the other, and it's a very complex landscape, and it's been very heated and contentious. As contentious within an organization like CEP, these discussions play out, you could say, within CEP, and it's particularly contentious within the community. And I think the publishing industry has made major mistakes over the last few years in how it presents itself, how it talks about issues, and how it has led to a level of distrust between the industry and that the people it's serving, academia, research. It's led to a level of distrust that has really held back progress. But I think we are. My sense is now that we are. A lot of people are at the point. So I say a lot of people within publishing and within academia globally, that everything has to be open access. It will be open access. It's inevitable. And if there's no place for embargoes, ultimately, what's an embargo? It's just propping up an old model. You need to maintain subscriptions. Whether you believe or not, subscriptions will continue to be paid if there's green, you can debate that, but fundamentally, everything's got to be free. And there's no place for embargoes. Okay, really, that's not full open access. So the licensing issue, there are a lot of licensing issues that I think still need to be resolved in open access. We still hit licensing issue, problems caused by licensing issues. And so for a simple example would be some historians, for example, or some humanities researchers, I should be less personal, so humanities researchers really don't want people changing their work. So they want a Creative Commons license that prevents derivative works. And does that, so another aspect is, well, automated reading? You know, does a human have to read it, or can a computer read it? And if a computer reads it, is that text and data mining that creates that essentially involves creating new copies and isn't permitted under a non-derivative works license? You know, these discussions are still going on. They're highly specific. But I think that what they highlight is that the licensing framework of Creative Commons, although it's been incredibly powerful and enabling, it underpins. I mean, you could describe open access in economic terms, or you can describe it in kind of Creative Commons terms. And I think in practical way, you know, describing it as open access means Creative Commons license content is a perfectly valid kind of description of it. But we do certain things as publishers that seem to be fighting against the spirit of openness, okay, and open sharing of works. Does a license that we apply, or an author applies, or we apply on behalf of an author, to pick up your point, Asun, does that prevent text and data mining that, you know, we shouldn't be doing? You know, we shouldn't be preventing it. I think that there are, you know, so with open access books, for example, where we are also committed, I think that books are going to go the same way as journals. Research monographs will go the same way as journals. A little bit behind, but it will happen. We're still dependent on print sales, so that means we put non-commercial restrictions on our Creative Commons licenses. That is also outside of the essential spirit, really, of open access, but we're doing it to keep so that people can undercut our printed books, which we need to finance publishing books. So the use of licensing both protects the publisher's ability to produce high quality content, and also, you know, grants, you know, what can be done with that work. It's to put the work out and into the whole world so that society as a whole can benefit. And sometimes these tensions, well, it creates tensions, contradictions that probably can't be resolved thoroughly within a Creative Commons system. So it's not a perfect solution by any means, but it is very much, you know, has enabled progress to be made. And I think that the economic impact of open access is really difficult. Okay, so we've heard lots of issues here where people are saying there's no, Valerie, I think you said that you don't have an endless budget, right? That's well understood, right? That's a key problem. The answer to that problem is not necessarily to change the license terms, rights retention strategy. It's an economic problem, can't be resolved by a licensing problem fundamentally. So let me give an example about where CUP is at economically, right? So we're projecting, I think our managing director has said publicly 15% profit loss through the transition of journals to open access. That could be an underestimate, actually. But where we are is with the current read and publish deals and our current approach to open access, we think by 2025, we will have about 80% of the revenues we need to sustain our publishing program of journals. So that leaves 25% where we don't know yet where we'll get the revenues from. And that's bigger than our profit margins. And the projected revenue loss could easily be more than 15% anyway. So there's a lot of things have to happen, including cost cutting, you know, realistically, and improved efficiency and new ways of publishing, new models, new approaches. So a lot's going to change, but we don't have a full answer to the economic problems. But they are not going to be resolved by licensing approaches. And yeah, I want to come back to the initial point I made about that the industry has not presented itself particularly well to the community, and these discussions have not been particularly well. They've just been extremely heated. We will find a way. The industry will find a way for all content to be open access in a way that in the academia can afford. I mean, it just has to be, right? Because either someone else will come up with a new system and publishers will cease to be relevant, which is possible, or the industry will find a way to adapt and it will survive in the future. So it will be resolved, but it won't be, but it will only come about, the solution will only come about through a real kind of coming together and resolving of issues. So it does require a very, so I think CUP has, over the last couple of years particularly, been trying to change our relationship and the nature of our discussions into this more positive, realistic, frankly, approach. And I think other publishers are probably starting to do the same. So I think that the tone is going to shift, the nature of the discussions is going to shift. And I hope that at some point we can start to separate again the economic arguments around open access, which are very real and serious, and some of the licensing issues where there are difficulties that aren't particularly being addressed. And actually the things that are being addressed at the moment, I would say, are kind of surrogates for the economic problems. But I think the fundamental thing is that we can't use copyright as a kind of a single word surrogate for all of the problems in open access. And if only copyright law was different, or it wasn't there, then there will be no problem. Copyright has been the bedrock, protecting authors, giving authors control over their output for hundreds of years, and it will continue to be the bedrock, and it will therefore continue to be a bedrock for publishers as well in their interactions with authors and mediating between authors and the wider world. So copyright is incredibly important, and it's solid, and we will go through a process of starting to be able to look at the particular problems that we have in copyright, making sure that text and data mining can be done, making sure that humanities researchers are protected, all while ensuring that publicly funded research in particular, but essentially all academic, scientific knowledge that's put into the public arena is put in such a way where it can be used and for the benefit of global society. So that is happening, but the conversation needs to shift a little bit. And I think I could pick up on any particular points that people are interested in, but I think that would be my summary after listening to you, Asun, from certainly CUP's perspective. Thank you.
Thank you, Matthew, for that actually very holistic and elucidatory response back on the issues which have been raising concern and specific points made by Asun. And on the chat, and I've been looking at the chat, and there are so many questions on it, and I do wonder whether some of the participants actually want to ask it. But as you can tell if you read it, the questions, there are about 3 or 4 separate issues. So I'm going to bunch together the ones where I'm particularly concerned about, from my professional and personal angle, which is the role of copyright law in all this. I am a bit perturbed, perhaps, by one aspect of Asun's conclusion that copyright law may not be the problem, because I do feel that as the law to protect the author here, we are, and as an academic author, I am squeezed out of the entire bargaining process between institutions, research institutions, and the publishers, and whether or not there is a case for the United Kingdom to basically bolster copyright protection of individual authors as to what we can sign away. Because unlike the civil law countries, and those of you from civil law countries may or may not know about this, but we have very little protection compared to, let's say, French or Spanish copyright law. There are concepts such as the assignment of future copyrights, i.e. in relation to books, which have not even been written. There are no limitations on what an author can do. And whether or not UK copyright law, which is due for a revamp, can be turned so as to protect the author, the way we sign agreements, to take away clauses in the law which say waiver of moral rights And I do remember as a young academic having to argue with Sweet and Maxwell, no, I don't want to waive my moral rights. And they kept saying it's a standard publishing agreement. I mean, things like that should not be part of standard publishing agreements. And that the author should not be really in between that tussle between the institutional mandate and the publisher's agreement, which is what happens in a lot of cases. The second point, which I'm concerned about, I'm trying to see whether anyone's brought it up in the question, is my relationship with the collecting society. Because in one sense, both of you have said there are a lot of stakeholders involved in this. One of the stakeholder here is, of course, me, the contents producer. And I do want to stamp my little foot and say, if there is this future where a lot of it goes online, that a lot of it goes into open access, and as you said, there is an issue of who pays for the quality, which I agree with. And a lot of, I, together with all my colleagues, do prefer the far polished edited versions in journals than, you know, the accepted manuscript version, which is very clunky to deal with. But at some stage, some sort of payment, and especially if you say, Asun, that it's a competition law problem, and your one issue that you brought it out was transparency of costs. And somehow in this cost transparency, there is a sum paid by someone to a collecting society, that the institutions are paying this as well. It's not very transparent as to how some of this money comes back to me. So, for example, ALCS, unless there's changed in the last year, have this policy of stop paying academic authors after 3 years of their article publication. And I think I'm concerned that, you know, while the music industry protects its creators, the publishing industry and the academic industry, in a way, doesn't actually protect its content creators. So that's my query. I am looking, and now I just give it back to Asun. I hope you've looked at some of the amazing questions here, and can I just give you the floor back? And if anyone, I don't know whether it's been allowed, but if anyone wants to speak into open mic, please put your hand up. I give it back to you, Asun. Oh,
sorry. Yeah, thank you.
I'll call you Chris after Asun. Yeah.
No, I actually wanted to discuss with Chris. Chris made a comment about my vision of copyright, but I would like to contrast with him what he said on the chat. He doesn't agree with me, I think, on this point. Chris?
Go ahead.
Hi there, Asun.
Hi.
Thank you so much for that. It was fantastic. And just to let you know, I met up with Asun earlier this week, so we've already had a bit of a discussion about her research and where she's ended up with. I'm not saying I agree with this, that you should have no copyright protection at all for scholarly works, because there is clearly some major issues with that. How would you define what scholarly works are anyway, to say that they no longer attract copyright protection? But I think one of the things to bear in mind, and why I think that it is still a copyright issue, is that we're all talking, and Uma, you were talking there about the author. Where does the author stand in this? The whole point of copyright is that copyright incentivizes authors to write and create new work. But what we're talking about here in terms of scholarly communication is more an acceptance. The philosophy behind it is that it is a commons. It's created, it's that we're part of a team, scholarship throughout history and all over the world, combining our efforts to create something collectively. And therefore, if you put into that the logic of individual author is given exclusive rights that goes out and allows them to make the best deal for their own private interests, it is at odds with the idea of this being a public commons. So what I'm suggesting is we should be thinking about how the concept of copyright, and as Matthew says, copyright is rock solid, it's existed for centuries. But this is a completely different environment we're in now. The internet, all the digital network technologies, the whole way we work changes everything. And it's not about the traditional publishing industry where we were limited by the fact that we had to produce copies of things that required investment in paper and printing. So I'm suggesting that if we do say, well, it's down to individual authors, then we'll end up with a system that doesn't work, because it's easy to fragment individuals and talk about their self-interest. And Uma, the point you make about collecting societies and how they work, the amount of money that academic authors get through that collecting society route is tiny, it's minimal, and it's a symbol for me of that the publishing industry has in place to kind of say, here, authors, you are getting something from this copyright system, but it's pennies, it's peanuts compared to how things work. We need to rethink, and I think there's a culture shift in what academia means, and I think that moral rights area is what we really need to strengthen. The fact that we recognize that the real value that comes from academic authorship is the ability to say, I wrote this, I did this, this is how I link it with other people. And that if we think about it from the reason why copyright law needs to be addressed, I think, is to actually dismantle some of those concepts and actually look at how, clearly the money needs to come from somewhere. But if we're talking about the author having those exclusive rights, it doesn't really work for me. So I think that's why we need to think radically.
I'm going to answer shortly. I'm sure Uma and Matthew also would like to make some points. I think the technical environment has changed radically in the last 50 years, but I don't think that does imply a change in the copyright law and in the recognition of copyright. I think that what modulates, what can change the copyright law is, in this case, the public interest in scientific knowledge. It doesn't matter if now we have, it is true that the open access to academic publishing has been discussed only when everything is digital and only when the scientific articles are available online. But I don't think this justifies, from the legal point of view, from the dogmatic of what is copyright, that it has to be open access mandatory. I think authors, when they create a work, they deserve a right, an exclusive right on that. The law has to impose some mandates. For example, the exception of data mining that Matthew mentioned, it is justified on scientific research. But I believe that authors are, as Uma said, we are the content providers. And some authors work in academia and they have a collective support, but many researchers, they are free researchers that work on their own, that they don't have so many fundings, and they do research and they publish. And I think that copyright is an incentive to create, but also many scientists and researchers, they do that regardless of copyright. They do that because they have an interest on research, and it's like a challenge for them to research and to publish. But I think that it is legitimate to provide them, to grant them a copyright. If they want to share everything, perfect. But they need to have the right to decide if they give up or not the rights. Sorry, if Uma or Matthew.
Yeah, I think we're short of time, so I'll be really brief. Yeah, it's interesting, Chris. I think, I mean, I do know that copyright, at its very conception, is a merge of economic and, legal concepts, right? It was designed to allow authors to profit from their creative work, right? But I'd like to kind of emphasize that my perspective, working in a publishing company that's trying to flip everything to be open access, really trying as hard as we can, as quickly as we can. The economic problems are distinct from the licensing problems, and the issues are bound up at the moment. So yes, I think you're right. I think while I say copyright's the bedrock, I admit that there are difficulties and changes needed, and I don't, I'm not an expert. I don't know what they are. I see certain issues. There are much deeper issues. Yes, stuff needs to happen. But I think I don't think the issues in academic publishing at the moment it's right to try to fix both problems. You know, use one to solve the other problem, licensing to solve an economic problem, vice versa. So that will be my follow-up. But yes, it's a valid point, Chris. Thanks.
I actually have a very quick query, which I should have asked as soon, and also Matthew and everyone else here, which is, I'm just being a devil's advocate. Do you think there's too much reliance on CC licenses? I did work on CC licenses for UK when it first started on the board, and I just wonder whether we are making it a de facto other license without necessarily having any input into it. That's all.
Yeah, I've kind of wavered on this. I think they've served the industry so well, and they're serving us well enough at the moment for the heart of the open access transition. But I think you're right. There are issues with it. I know some people think that they're not fit for purpose, and I've almost thought that myself sometimes. But I don't think. I think they are. But there are issues. Yeah.
Well, the fact is, as I said, as a devil's advocate, when the publishing industry says they're happy with it, I go, why? And I start suspecting it.
Well, that's something I'd love to talk to you more about.
Asun, do you think there's too much acceptance?
No, I don't agree. But I think that exceptions are one of the most interesting issues on copyright law, because it's really the way to balance the different interests involved in all the areas of copyright. I mean, the music industry, and of course in the academia, education, then exceptions really play a very, very important role.
Yeah, but the CC license is being done by private bodies as a private ordering system.
Yeah. Well, it's different in Spain, so I can't really judge the situation here in the UK.
No, that's fine. No, I've been told, yes, we should end the whole thing by 1 o'clock. There was a lot of questions. I hope the panel came back and answered some of them. I think there's something to be said about, having a lot more research in this area, especially like the one Asun just did, which is really empirical research. We do want to know what's actually happening in the licensing clauses. I'm so happy because I learned here about Dutch law as well. Someone's given me different sections to read up on. But I hope to see you all again for the next event. Thank you so much, Asun and Matthew, for this. And to Christine, our events manager. And if you want to... I haven't noted yet. If you want to join up to the next one, there are ways to do it. I should know, but you know how to contact us if you want to get in touch with the speakers today. So thank you so much, everyone. And
thank you. Goodbye.
Seeing you
Thank you very much, and goodbye.